Okay, so 160 really quick. This is the duties when somebody gets arrested. This is when they have to be fingerprinted. Charged with a felony, a misdemeanor in the penal law, a misdemeanor outside the penal law, which would be a felony if they had prior conviction, so like a DWI, and loitering for the purpose of engaging in a prostitution offense. In addition, they may take fingerprints if the cop is unable to identify a person's identity or reasonably suspects the identity given by the person is not accurate, or reasonably suspects that the person is being sought by law enforcement officials for the commission of some other offense. Whenever they're required or permitted to take fingerprints. The taking of fingerprints and submission of available information concerning the arrested person or the defendant as the facts and circumstances of the crime charge must be in accordance with the standards established by the Commissioner of DCJS. And the duties upon receiving the fingerprints, DCJS is to classify them and search its records and then promptly transmit the agency or a cop a report containing all the information on file with defendant's previous records. So they got to basically send the guy's rap sheet, including JD and YO things, or if there's no record, they have to send something stating the defendant has no record according to its files. Such a report, if certified, constitutes presumptive evidence of the facts so certified. If the fingerprints are not legible, then they have to be returned and explain the defects and request that if they possibly can, redo the guy's fingerprints. That one doesn't have a time rule, the other one says promptly. 160.20. Upon taking the fingerprints, they must, without unnecessary delay, forward 2 copies of the fucking fingerprints to DCJS. 160.45 just says that no DA, cop, or any law enforcement agency shall require a victim of a sexual assault crime to submit to any polygraph test or psychological stress evaluator examination. And when they define those things, that's anybody alleged to have sustained offense under Article 130 or Section 255, 25, 26, or 27 of the penal law. Then the next thing is 160.50. That's when they have to first seal everything in the court record. And the only things that aren't included in this are not including published court decisions or opinions or records and briefs on appeal. Those are not included in this. Then this next thing is about who can see the sealed records. And that is the accused or his agent, the prosecutor in any proceeding where the accused has moved for an order pursuant to Section 170.56 or 210.46, a law enforcement agency upon ex parte motion in any court except a town or village court, because it says a superior court, city court, district court, or New York City criminal court. If the agency demonstrates to the satisfaction of the court that justice requires that such records be made available to it, any New York State or local officer or agency with responsibility for gun licensing when the accused made the application for the license, or New York State Department of Corrections and Community Supervision when they're on parole supervision as a result of conditional release granted by the parole board, a prospective employer of a police or peace officer, but in that case, that you have to also give them to the person that applied to be a police officer or a peace officer, and they have to get the opportunity to make and give an explanation about the arrest. The probation department responsible for the supervision of the accused when the arrest, which is the subject of the inquiry, is one where the accused was under supervision. So if the guy was on probation and the case got dismissed or he was acquitted or whatever, then the probation department can get the sealed records. The next thing is a list of the actions that are considered terminated in favor of the accused. If I don't want to get this details, fucking skip this part, because it's all common sense. In order to dismiss the entire accusatory instrument against such person pursuant to 170.30, 170.50, 55, 56, 180.70, 210.20, 210.46 or 47 was entered or deemed entered, or an order terminating the prosecution against such person was entered pursuant to 180.85, and the people didn't appeal. All of these are going to say the people either didn't appeal or they appealed and they lost the appeal. C, a verdict of complete acquittal. D, a TOD. E, an order setting aside the verdict pursuant to 330.30 or 370.10. Hold on, I'm going to look that up quick. Okay, it just says we're at JHO, so let me look at 330.30. Oh, that's a motion to set aside verdict. So motion to set aside a verdict. I think that's when it's dismissed on appeal. Yeah. Okay. So 470 dismissed on appeal. 170-30 dismissal in the interest of justice. 170-55. I think that's an ACD. 56 is an ACD. 170-50 is, a lot of this is common sense. Motion in Superior Court to dismiss prosecutor's information because the grand jury's evidence was not legally sufficient or the proceeding of the grand jury was defective. 180-70, 210-20, 210-46, or 210-47 was entered or deemed entered, or an order terminating the prosecution pursuant to 180.85, verdict of acquittal, trial order dismissal, order setting aside a verdict, order vacating a judgment pursuant to 440, no new trial has been ordered. An order of discharge pursuant to Article 70 of the CPLR. So that's like if there's a habeas corpus proceeding and there's an order of discharge, which invalidates the conviction. H, where all the charges are dismissed pursuant to 190.75, so that's got something to do with the grand jury. In such event, the clerk of the court that impounded the grand jury shall serve the certification of the disposition on DCJS and the appropriate PD or law enforcement agency. Prior to the filing of an accusatory instrument, the prosecutor elects not to proceed, and in that case, the prosecutor has to tell DCJS and the cops, or the cops decide not to proceed, and if they already printed the guy, then they have to serve notice on DCJS. An order pursuant to 215.40 was entered, or there was the marijuana was the only offense, and 3 years have passed since the conviction. Okay, so then for a person who is in favor, the action was terminated prior to the effective date of this section, upon not less than 20 days notice to the DA, may upon motion apply to the court for the relief sought. And such certification shall be granted by such prosecutor. So if it happened like the prosecutor or the cops decide not to proceed, they have no choice. They have to seal them if the guy makes the application. And if they make the application to the court on 20 days notice to the DA, the order shall be granted unless the DA demonstrates that the interests of justice require otherwise. Alright, then 160.55. If a person under age of 21 gets the a BWE or a DWE, and a finding in favor of the motorist is rendered. I don't understand this. As soon as practicable, but not how the fuck do they have 3 years to notify somebody? Alright, I don't understand this section, but just remember that when they're talking about 160.55 and sealing a person under 21, something about 3 years and whichever is greater. So when they turn 21 or 3 years and sealing, or something like that. And it has to do with waiver of a hearing. Loitering for a purpose of a prostitution offense is not sealed. No, harassment in the second degree against a member of the same family or household is not sealed. And DWAI is not sealed. I think those are the 3 that it's not sealed. And that one about the harassment thing, that's only if they serve notice pursuant to 170.10. So the DA has to serve notice pursuant to 170.10. Next is the guy that gets a drug offense and completes the judicial diversion program or another program that's judicially sanctioned of similar duration. They complete the sentence, they're eligible to have the offenses sealed. They're conditionally sealed for no more than 3 of defendant's prior eligible misdemeanors, which shall be limited to drug misdemeanors, and they only may seal the records of defendant's arrests and prosecutions and convictions when they got an FBI and DCJS report, and the defendant or court has identified the convictions which relief may be granted, and they have to notify the DA and court in each jurisdiction. Those people get an opportunity to complain about it, which shall not be less than 30 days. And they can comment and submit materials to aid the court in making such a determination. So in reality, they're going to fucking throw it in the garbage and no one's ever going to notify anybody and they're just going to seal it. Records pursuant to this section are made available to defendant or his designated agent. I think this is all the same thing. Gun licensing, prospective employer, peace or police officers. Oh, but this one doesn't have the probation thing in it because obviously the sentence would have been completed. And the court shall not seal defendant's record pursuant to this section while any offense is being charged. This is all about the drug thing. And then in 160.59, it talks about eligible offense means any crime other than a sex offense, an offense in 263 penal law, a violent felony offense, a felony offense defined in Article 125, so it's like the homicides, a Class A felony offense, a felony offense in 105 where the underlying is not eligible, an attempt to commit offense that's not eligible if the attempt itself is a felony, or any offense that required registration as a sex offender pursuant to 6-C of the correction law. When a defendant is convicted of one or more eligible offense as part of the same criminal transaction, those are considered one offense. Sentencing judge means the judge that gave sentence, or if he's not there anymore, any other judge who was sitting in the criminal court where the judgment of conviction was entered. I think this is the one that has a 45-day rule in it. A defendant who has been convicted up to 2 eligible offenses, but not more than 1 felony, so you could have 1 felony or 2 misdemeanors, may apply to the court where he was convicted for the most serious offense, or if they're the same weight, then it's the last conviction. So that's where he applies. Okay, so he either applies where the most serious conviction was, I have to go, where the most serious conviction was, or if they're all the same weight, then where the last conviction was. And it has to have a sworn statement of the reason why the court should, in its discretion, grant such sealing, along with any supporting documents. So there's 5 things. The certificate of disposition, sworn statement of the defendant as to whether he filed this before, a copy of any other application that's been filed, sworn statement as to the conviction or convictions for which relief is being sought, and 5, a sworn statement of the reasons why the court should seal it. They have to serve this on the DA also, and the DA shall notify the court within 45 days if he objects to the application for sealing. It has to be assigned to the sentencing judge, if possible, who shall request and receive from DCJS a fingerprint report, including any sealed or suppressed records. They shall also include an FBI criminal history report. The division is hereby authorized to receive information from the FBI for this purpose and to make such information available to the court, which may make this available to the DA and defendant. The sentencing judge, county or Supreme Court, shall summarily deny defendant's application when he was required to register as a sex offender. He previously got sealing for the maximum number of convictions under the section. He previously obtained sealing. Isn't that what it just said? Or he got sealing under 160.58. The time period in sub 5 has not been satisfied, so it hasn't been the full 10 years yet. It's got to be 10 years. Defendant has an undisposed arrest or charge pending. Defendant was convicted of any crime after the date of the entry of judgment on the last conviction for which sealing is being sought. The defendant has failed to provide the court with the required sworn statement why the court should grant the relief, or defendant has been convicted of 2 or more felonies or more than 2 crimes. So no 2 felonies and no 3 crimes. Okay, if the application is not summarily denied, the court can seal up to 2 of no more than 2 eligible offenses, but not more than 1 felony. It says got to be 10 years has elapsed, and the period that he was in jail is not included in the calculation. Okay, so if there's a federal firearm check, a conviction which is sealed pursuant to this section is included within the definition of a conviction for the purpose of any criminal proceeding in which the facts of a prior conviction would enhance a penalty or as an element of the offense charged. No defendant, this is interesting, no defendant shall be required or permitted to waive eligibility pursuant to this section as part of a plea of guilty, sentence, or any agreement related to a conviction for an eligible offense, and any such waiver shall be deemed void and wholly enforceable. It shall be deemed void. I think they mean wholly unenforceable, maybe. Yeah, they meant unenforceable. Because in number 11, it says no defendant shall be required or permitted to waive eligibility for sealing, and if they do waive it, it's deemed void and wholly unenforceable. Okay, so whenever they're sealed to 160.50, the person is restored to the status he occupied before the arrest and prosecution. It shall not operate as a disqualification of any person to pursue or engage in any lawful activity, occupation, profession, or calling, except where specifically required or permitted by statute or upon specific authorization of a superior court. No such person shall be required to divulge information pertaining to the arrest or prosecution. Oh, okay.